Then we've got a masterclass called Know Your Rights Employment Law.
Okay, tell us a bit about that.
That's run by barrister Ryan Clement.
Yeah.
And to pass the bar, he had to go through a lot of work. So, you know, he's got an inspirational story inside of that. And Mr. Clement, he's just going to be letting you know what to look out for when you're in jobs, especially around things like human resources, which is HR. And if you need to report something or disclose something that maybe a vulnerable adult or a young person has let you know, just what is the laws and how you can protect yourself in the workplace, which is important, right?
Definitely. I mean, you have to educate yourself because, I mean, a lot of people actually, they get into something and they don't know the full ins and outs of what they're actually entitled to.
There you go.
So yeah, definitely.
This is it. And then finally, if that was not enough for you, Jermaine, we got just a little bit more because we like to give more at employment.
Give on give.
Keep on giving.
Yeah.
Hello, my name is Ryan Clement and I practice in barrister and employment law. Today we're going to talk about grievances. Yes, if you're an employee, that document you referred to in the offer letter. If you're an employee, it's a document that was referred to in the offer letter that you signed to say you understood and you read it. Yes, that one. The one that you only look for when there's a problem, or you only look for when someone raises a grievance. Then you look to see what a grievance is, or what you're supposed to do about it. Well, the best place to start is, what is a grievance? Contrary to what some people might believe, a grievance is not about any complaint, about anything, or about anyone in the workplace. It's a bit narrower than that. In fact, it might be good practice for an employer to deal with a complaint raised by an employee, but that doesn't necessarily constitute a grievance. A grievance is defined in the ACAS code, and I suggest that you look at this document because it's a very important one, as a concern, problem, or complaint that employees raise with their employers. There is no one fixed definition of what a grievance is. However, put succinctly, a grievance is a problem or complaint raised by an employee to their employer, and the way in which that grievance, i.e. the problem or complaint raised, is handled is prescribed by the employer's grievance procedure. The ACAS Guide, Discipline and Grievances at Work, the February 2019 version, defines a grievance as, and I quote, a problem or concern that an employee has about their work, working conditions, or relationships with colleagues or managers. It also gives a non-exhaustive list of issues that may cause grievances, being terms and conditions of employment, health and safety, work relations, bullying and harassment, new working practices, working environment, organisational change, and discrimination. Regarding grievances about fellow employees, the guide says, employees may complain that they have been bullied, harassed, or discriminated against by another employee, or may complain about another employee's attitude, capability for the job, or even personal habits or personal hygiene. So, if an employee has a grievance, they should make it absolutely clear what their complaint is and whether they wish their complaint to be dealt with informally or formally. Many written grievance policies will state that if the employee has a grievance, then ideally it should be dealt with informally at the employee's election. And if not dealt with to the employee's satisfaction, they may wish to raise it formally. However, if dealt with informally, although mentioned in the grievance policy, there is no prescribed way of dealing with an informal grievance. For example, if your complaint is about a colleague, you can simply speak to your manager about it, who will hopefully speak to that colleague and matters will be resolved. Likewise, if your complaint is about your manager, you can speak to your manager's manager, who would hopefully adopt a similar course of action. However, if that doesn't work, then the aggrieved can choose whether or not to take the formal route and raise a complaint formally. Having set out clearly what the grievance is in writing and sent it to the appropriate person according to the grievance procedure, the employee should be invited to a meeting by the employer to discuss their grievance without delay, which the employee and their companion should make an effort to attend. Notably, the employee has a right to be accompanied at the meeting by a fellow worker, a trade union representative, or an official employed by a trade union. The companion is allowed to participate in the hearing to put and sum up the worker's case, respond on behalf of the worker to any views expressed at the meeting, and confer with the worker during the hearing, but does not have the right to answer questions on the worker's behalf, address the hearing if the worker does not wish it, or prevent the employer from explaining their case. It is important that the person chosen to conduct the grievance is capable and competent enough to deal with it. For example, in a case where the aggrieved has alleged discrimination or harassment, the person chairing the meeting should, ideally, be someone who has been trained in anti-discriminatory practices and attended equal opportunities courses. These, I believe, will make the chair attuned to the nuances of some complaints that may not appear on the surface to an untrained person to be a problem. For example, when hearing a complaint of harassment related to race, when, on the face of it, to an untrained eye, it may appear to be nothing more than a little harmless banter, and we've heard a lot about that in the news recently, it is important that the person hearing the grievance has a thorough understanding of the nature of the grievance and why the aggrieved feels the way they do. The chair should also ascertain what the aggrieved is seeking as a resolution. The chair should approach a grievance with an open mind and avoid forming a view before hearing the grievance and all the necessary investigations have been undertaken. It is important that the chair holds a meeting with the subject of the grievance to hear their side and respond to the grievance. It may be necessary to interview other people who may be able to assist with the investigation, especially when there are disputes of fact. Forming a view based on conflicting evidence can be very difficult. However, serious thought has to be given to weigh up the evidence and form a view based on why one set of evidence is more likely to be true than another. Grievances can be very stressful for both the aggrieved and the accused, which the employer should bear in mind when dealing with the grievance and the related investigations. I should state, however, the person hearing the grievance is to investigate the grievance and reach a conclusion on what has been found, rather than be swayed by the consequences of upholding or not upholding the grievance. For example, where there is conflicting evidence, where the chair is money to believe, for example, the aggrieved over the accused, it would be wrong for the chair to be influenced not to uphold that part of the grievance, because to do so would land the accused into trouble. Likewise, it would be wrong for the chair to be persuaded by the accused, but find in favour of the aggrieved simply to appease that person. Once a decision has been reached, then that decision should be communicated to the aggrieved in writing, setting out clearly what that decision is, the reasons for that decision, any action to be taken to resolve the matter, and the employee's right of appeal. If the employer exercises a right of appeal, they are allowed to be accompanied, again, with the same rights. Many appeals are not a rehearing of the grievance. The appeal procedure and process should make it clear if it is a rehearing or not. So if the right of appeal is limited to where the employee believes that the decision was wrong and is to give reasons, there's little to no value in the appeal simply repeating the nature of the grievance. The employee must state why they believe that the grievance outcome was wrong. For example, the chair omitted to interview the only independent witness to the conduct in question. And had the chair interviewed that person, it is highly likely that the chair would have reached a different, presumably favourable, conclusion. The appeal decision is final. If the employee is unhappy with the appeal decision, they can present a complaint to the Employment Tribunal by notifying ACAS, obtaining a certificate, and presenting an ET1. These are topics that I shall cover in later videos. Now we've gone through the technical part, let's go through one or two pointers. Grievances are very important and are to be taken seriously. A failure to do so by the employer could entitle the employee to resign and claim constructive dismissal. When I say taken seriously, I do not mean brushing it under the carpet. I mean investigate the grievance properly, transparently and fairly, as it is an implied term of the contract of employment that this will be the case. Again, in the absence of these, an employee, i.e. the aggrieved, may view the employer's actions as amounting to a breach of the mutual term of trust and confidence, and therefore take whatever action they deem necessary in the circumstances. It is important that the employer has an independent note-taker to record what has been said, both in the grievance hearing and, if there are any investigations, during those hearings also. After the notes have been taken, it is important that you get the attendees to read the notes and agree what has been said. If there are any disputes as to what has been recorded and what the attendee said was said during the meeting, then if the parties cannot agree on what was said during the meeting, then what the attendee says should be recorded in any event. What can be agreed should be signed as such by the attendees. If new information comes out from the investigation that was not addressed by the aggrieved employee, it is advisable that the points are put to the aggrieved employee so that the aggrieved employee can comment and/or give their version of the events. After the investigation process has been concluded, the person hearing the grievance must do at least two things. Firstly, do not rush the decision and view the evidence in the round. Secondly, must check the time frame within the grievance policy, and if the person hearing the grievance is likely to overrun, they should inform the aggrieved employee accordingly. Having reached a decision, it is common for the chair to call the aggrieved employee and explain the findings and outcome of the grievance. If the grievance is upheld, that's usually the end of the matter for the aggrieved employee. However, if it's not upheld, then, as stated earlier, the aggrieved employee ought to be told about their right of appeal and to whom to address it. Either way, however, this is not the end of the matter, because in the case of where a grievance has been upheld, there may be consequences for the person against whom the grievance was raised. For example, it is possible that in the case of discrimination, of harassment, the person may face some disciplinary measures in accordance with the company policies. This can sometimes cause a problem for the person who raised the grievance in the first place, because they want to be assured that the person against whom they raise the grievance is going to be punished accordingly. However, it is not a matter with which the employee can get involved. Any disciplinary measures or disciplinary consequences are a matter solely between the company and the employee in question, i.e. the person against whom the grievance was raised, and is to be treated by the employer in the strictest confidence. But what is the position if the grievance is not upheld? Like I said, if the employee wishes to exercise their right of appeal, they are entitled to be accompanied. It is most unusual that an appeal will be a full rehearing. So the person hearing the appeal will have to be very careful to make sure that they not only address the points raised in the appeal, but the appeal is one that is properly raised. Although I do not suggest for one moment that the person hearing the appeal approaches it as if it were an appeal in a court of law. Whatever is the case, the employee must be given the full opportunity to have their appeal heard and have their say. Although it is an appeal hearing, if the person hearing the appeal believes that further investigation is needed, then they should adjourn the hearing and undertake the necessary investigation, and if need be, put the various points to the employee. After this part has been concluded, similar to the person who heard the grievance, the person hearing the appeal must take their time and consider all the points raised in the appeal before arriving at and making their decision. The decision will be final. In other words, there'll be no other further rights of appeal against the appeal officer's decision. This naturally concludes matters, but of course, life is not that simple. If the employee still feels unhappy by the decision, depending on the nature of the dispute in question, the employee has an option on whether or not to take it further to the employment tribunal, or they may just simply choose to resign and move on. Finally, I should touch on another dispute resolution option, and that is mediation. This option is becoming more and more popular, not only through ACAS, but by trained internal mediators. It is important to note, however, Mediators do not judge, make findings of fact, or reach a conclusion on the grievance. They are there to facilitate or assist the parties in resolving the matters in dispute and or raised as part of the grievance. The outcome of the mediation is not binding on the parties, although in order to avoid any confusion, the parties are strongly encouraged to sign up to what they believe has been agreed as part of the mediation process. I hope you've enjoyed this video. Until next time.